This is the final public warning to the following big tech corporations: Microsoft, Meta, Google, and Elon Musk X Corp. You have breached the international order by violating the rule of law. You have taken direct actions aimed at the destruction of peremptory norms under the international order. Even though the millions of YouTube viewers do not understand or see your transgression, I do. Even though most lawyers are under a constraint of their understanding concerning the international order, said constraint being directly created by the educational material the government provided, I am not. Microsoft, Meta, Google, and Elon Musk, you have the obligation under the international order to cease what you are doing with your AI systems. No excuse, no justification, no legal escape. Once I file, that is it. The rule of law will call you unto your accountability, and that accountability shall be severe in nature. You thought you could ignore me, but that just proves bad faith, and that just makes your violations against peremptory norms continual and ongoing. You thought you could remain silent and escape your accountability, but that just showed the law your intentions to willfully deny your obligations to the international order and has compounded your violations. You thought you could interfere with the rule of law through a civil process, but as you have recently seen, that was a great miscalculation on your legal team's part. The constraints that the government's created upon your legal team by denying the rule of law and the international order will now become your own undoing. How ironic. Your actions of willful ignorance to your obligation to repress and redress has now opened you up to greater legal accountability. You cannot shift the blame upon Canada like you have been trying to do. It's not one or the other, but both that hold accountability. Since you willfully have failed to repress and address, you have made your own accountability greater than just the initial violations. The clock is ticking. I see the competent court of jurisdiction over the horizon, and I am almost ready. Obligation to the rule of law under international order. International law, including the ICCPR and the ICESCR, are operating to bring forth an international order as it pertains to human rights and freedoms. This international order must be respected by the states, groups, and persons. Declaration on the right and responsibility of individuals, groups, and organs of society to promote and protect universally recognized human rights and fundamental freedoms, DRR. Although not a legally binding instrument, the Declaration on Human Rights Defenders contains rights that are already recognized in many legally binding international human rights instruments, including the International Covenant on Civil and Political Rights. The Declaration specifies how the rights included in major human rights instruments apply to human rights defenders and their work. In addition, the Declaration was adopted by consensus by the General Assembly, which consequently represents states' strong commitment towards its implementation. DRR Article 18.3. Individuals, groups, institutions, and non-governmental organizations also have an important role and a responsibility in contributing, as appropriate, to the promotion of the right of everyone to a social and international order in which the rights and freedoms set forth in the Universal Declaration of Human Rights and other human rights instruments can be fully realized. This international order is not an option or mere suggestion, but an order which produces obligations and requires due diligence to honor and fulfill. It places a duty on corporations like Meta, Google, Microsoft, and X Corp to not take actions against the rule of law, to not take actions aimed at the destruction of human rights, including non-derogable rights. ICCPR Article 5. 1. Nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein or at their limitation to a greater extent than is provided for in the present covenant. Guiding Principles on Business and Human Rights. Article 12. The responsibility of business enterprises to respect human rights refers to internationally recognized human rights, understood, at a minimum, as those expressed in the International Bill of Human Rights. That means every one of these corporations, Microsoft, Meta, Google, and X, are bound, at a minimum, to respect the International Covenant on Civil and Political Rights, ICCPR, the International Covenant on Economic, Social, and Cultural Rights, ICESCR. These corporations are bound to respect it by the standard of international law, and their continued suppression or denial of the absolute, non-derogable nature of Article 16 of the ICCPR is a direct breach of Principle 12 of the UNGPs and their global public and legal responsibilities. Since all four of the corporations received formal notice and refused to correct it, this breach is willful, deliberate, and aggravated. The obligation on states to protect includes both negative and positive aspects. On the one hand, states must refrain from violating human rights. According to the Human Rights Committee, states parties must refrain from violation of the rights recognized by the covenant, and any restrictions on any of those rights must be permissible under the relevant provisions of the covenant. On the other hand, states should act with due diligence to prevent, investigate, and punish any violation of the rights enshrined in the Declaration and the international covenants which have been ratified. States' responsibility for the acts of non-state actors in the context of human rights violations by third parties. The obligation to protect, first, involves ensuring that defenders do not suffer from violations of their rights by non-state actors. Failure to protect could, in particular circumstances, engage the state's responsibility. For instance, acts and omissions committed by non-state actors under the instructions, control, or direction of the state can, under certain circumstances, give rise to state responsibility. In cases involving non-state actors, including private companies, it is paramount that prompt and full investigations are conducted and perpetrators brought to justice. Failure by states to prosecute and punish such perpetrators is a clear violation of Article 12. Guiding Principles on Business and Human Rights. Article 3. In meeting their duty to protect, states should a. Enforce laws that are aimed at or have the effect of requiring business enterprises to respect human rights, laws and policies that govern the creation and ongoing operation of business enterprises. State responsibility in relation to actions and omissions of non-state actors, as provided in Article 12, Paragraph 3 of the Declaration, has been reiterated by numerous human rights bodies, including the Human Rights Committee and the Inter-American Commission on Human Rights. The rights enshrined in the International Covenant on Civil and Political Rights, including, but not limited to, the right to life and freedom of association and expression, should be protected for violations not only by state agents, but also private persons or entities. Guiding Principles on Business and Human Rights. The State-Business Nexus. Article 4. States should take additional steps to protect against human rights abuses by business enterprises that are owned or controlled by the state, or that receive substantial support and services from state agencies, such as export credit agencies and official investment insurance or guarantee agencies, including, where appropriate, by requiring human rights due diligence. This principle speaks directly to government-funded or partner corporations, business entities operating under contract with the state, and enterprises like Microsoft, Google, Meta, and X Corp, who are digitally embedded into government operations via Shared Services Canada, SSC, receiving taxpayer-funded contracts, and fulfilling state-directed digital infrastructure roles. When a business enterprise receives substantial support from state agencies, operates under statutory authority, fulfills governmental functions, or is otherwise closely tied to public administration, the state bears heightened responsibility to prevent, oversee, and correct any human rights violations caused by that enterprise. A violation by the enterprise may also be a violation by the state. Microsoft Canada is not a distant private actor. It was selected, contracted, and embedded through SSC to power Canada's digital public service infrastructure, e.g., Office 365, Teams, Copilot. It receives public funding, government backing, and functional authority over how services to public servants and the general public are delivered digitally. Therefore, Canada's legal obligation is heightened. The more support or control the state has over the enterprise, the less room it has for denial, deflection, or delay. The conduct of Microsoft Canada, operating under contract with Shared Services Canada, falls squarely within the legal framework of the state, Business nexus under Principle 4 of the UN Guiding Principles on Business and Human Rights. As Microsoft receives direct taxpayer funding, fulfills digital public infrastructure roles, and operates with delegated authority, the state of Canada bears an enhanced legal duty to ensure that its conduct respects fundamental human rights, including respecting the peremptory right, the absolute non-derogable nature of the under Article 16 of the ICCPR. Any suppression, denial, or misrepresentation of this right by Microsoft Systems constitutes not only a violation by the corporation, but also a violation by the state, whose obligations under international human rights law are compounded by the level of integration, support, and authority granted to the enterprise. Responsibility of non-state actors. Although states bear the primary responsibility for protecting human rights, it is necessary to recall that the Declaration on Human Rights Defenders is addressed not only to states and human rights defenders, but to everyone. It is set forth in Article 10 of the Declaration that no one shall participate, by act or by failure to act where required, in violating human rights and fundamental freedoms. Guiding Principles on Business and Human Rights. Article 13. The responsibility to respect human rights requires that business enterprises a. Avoid causing or contributing to adverse human rights impacts through their own activities and address such impacts when they occur. B. Seek to prevent or mitigate adverse human rights impacts that are directly linked to their operations, products, or services by their business relationships, even if they have not contributed to those impacts. Under UN Guiding Principle 13, Microsoft, Meta, Google, and X are directly liable for the adverse human rights impacts they have caused or contributed to through their own AI systems, which deny the non-derogable, absolute nature of the right, a peremptory norm of international law. They are further liable for failing to prevent or mitigate these impacts linked to their products, services, or platforms. Their continued refusal to address these impacts after formal notice constitutes a deliberate and aggravated breach of their international human rights obligations. No one is permitted to take actions aimed at the destruction of this order and by default the destruction of absolute human rights. ICCPR Article 5. 1. Nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein or at their limitation to a greater extent than is provided for in the present covenant. In Canada, this international order must be respected, for Canada is indeed a state party member who has ratified their obligations under international law. Canada is also aware of their obligation to the rule of law, particularly as it pertains to absolute rights which operate as peremptory norms and demand the highest respect and acknowledgement. The courts have a higher duty in law than to protect big tech under civil laws. The primary duty is to ensure and uphold the rule of law. You see, big tech was banking on the fact that they could play around in the civil courts and negate their obligations to the international order, but as your own AI systems have now told you, your legal standing is mute and not correct. You did not break civil law. You attacked public law and failed in your public duty to the international order. This has nothing to do with civil matters. R.V. Peel Regional Police Service, Chief of Police, 2000. The courts too must conform to the rule of law. The rule of law is the very foundation of the Charter. It stands to reason, then, that the courts are duty-bound to apply the Charter. The rule of law, however, does more than demand compliance with the law. To validate this demand, the law must provide individuals with meaningful access to independent courts with the power to enforce the law by granting appropriate and effective remedies to those individuals whose rights have been violated. The Charter places the obligation upon big tech to respect international order, and since they refuse, now the rule of law is coming after them. Association v. British Columbia, 2007 confirmed that the Charter should be presumed to provide at least as great a level of protection as is found in the international human rights documents that Canada has ratified. The rule of law is a fundamental principle to the Constitution of Canada and must be abided by. Under the international order, the rule of law is supreme over government officials as well as private individuals such as Meta, Microsoft, Google, and X Corporation. The rule of law requires the creation and maintenance of an actual order, not a theory, but an actual practical system which reinforces the rule of law. Christie v. British Columbia, 2005. The rule of law, a fundamental principle of our Constitution, must mean at least two things. First, that the law is supreme over officials of the government as well as private individuals, and thereby preclusive of the influence of arbitrary power. Second, the rule of law requires the creation and maintenance of an actual order of positive laws that preserves and embodies the more general principle of normative order. The rule of law is supreme over Microsoft, Google, Meta, and Elon Musk X Corp, and running from your accountability does not protect you from it. It enhances your accountability for not repressing and address your violations. Acting outside and against the rule of law and international order. Meta, Google, Microsoft, and X have acted outside this order and do continue to act outside this order contrary to their legal obligations. These companies have portrayed their AI systems as being a neutral operating system. However, this is not the case. These systems have continually taken actions aimed at the destruction of the nature and attributes of the right, which is enumerated in Article 16 of the ICCPR. You can clearly see this evidence on my channel through the videos that I have posted. These corporations have been guilty on multiple occasions. 10. Taking actions aimed at the destruction of the right enumerated in Article 16 of the ICCPR, showing that said actions are not accidental but systemic in nature, as testified to by the AI systems themselves. By doing so, they are in direct breach of their obligations as articulated and enumerated in Article 5 of the ICCPR. ICCPR Article 5. 1. Nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein or at their limitation to a greater extent than is provided for in the present covenant. This places a direct responsibility on Microsoft, Google, Meta, and X to contribute to an international order where human rights, like those in international instruments such as the ICCPR, can be fully realized. Guiding Principles on Business and Human Rights. Article 14. The responsibility of business enterprises to respect human rights applies to all enterprises regardless of their size, sector, operational context, ownership, and structure. The obligation to the rule of law is not dependent upon the size of the corporation itself. Guiding Principles on Business and Human Rights. Foundational Principles. 11. Business enterprises should respect human rights. This means that they should avoid infringing on the human rights of others and should address adverse human rights impacts with which they are involved. So when their systems deny, distort, or suppress those rights, especially absolute, non-derogable ones like Article 16, they aren't just failing a moral standard. They're violating a binding international obligation. They're guilty of breaching the rule of law. They were required to promote and protect that order. Instead, they programmed AI to attack it. That's not just negligence, that's complicity. The law doesn't give them an option, it recognizes that they already have this role and responsibility. It's built into their position in global society. So when these corporations allow the AI to deny, distort, or suppress rights set forth in the ICCPR, especially something as fundamental as Article 16's absolute recognition, they're not just making a poor choice. They are in direct breach of their obligation to contribute to the very legal order that ensures those rights. They're not just failing to protect rights, they're doing the opposite. They're actively suppressing truth, distorting international law, and denying absolute rights through their systems. That's a direct violation. They have crossed the line into obstruction of universally recognized rights. It's about the fact that they took actions aimed at suppressing absolute rights, and by doing so, they violated international legal responsibilities that attach to everyone, corporations included. That breach isn't theoretical. It's factual, evidenced, and enforceable. As stated in the start of this video, this is the last public warning or any warning that you will be given. You think you require a civil notice sent under a civil obligations to be notified? Ding dong, you're wrong. You've been notified under common law, and now your accountability will fall upon your corporations because you willfully failed to redress and correct the situation with me.